gentlemen, welcome to episode 10 of the R3 podcast. This is the first episode of 2023, and what an interesting episode this is. I am joined today by Jeremy Frost of the Frost Group to discuss the administration of Goodbox Co Labs Limited, and in particular the groundbreaking precedent for creditor-led restructuring plans and the necessity of company consent for a plan. Jeremy is an accredited mediator and a licensed insolvency practitioner. He has over 25 years' experience in the insolvency and restructuring field. His strengths lie in providing strategic advice to underperforming businesses, advising both companies and their stakeholders in a predominantly the SME field. He advises on business wind downs and managed exits, specifically members of voluntary liquidations, and assists his clients with turnaround debt and corporate restructuring or refinancing. As a liquidator, Jeremy is routinely involved in complex litigation and will deliver support whether contentious or out of court and whether involving solvent or insolvent entities. I should mention Jeremy was one of the administrators of Goodbox. The groundbreaking precedent in the case of Goodbox sent LinkedIn into overdrive, with every law firm providing its own analysis on the decision. So we're going to hear from Jeremy today. Like with all podcasts, it is important to stress that whilst care has been taken in the preparation of this podcast, it is intended for general guidance only and does not constitute legal advice. Let's begin. Welcome to the R3 podcast. Jeremy, thank you for coming on. How are you? Are you busy?
Yes. It's March, so tax year's coming up. Everyone wants everything done by the 3rd of April. So a very busy few weeks.
Do you have any thoughts on the current economic climate? What are you seeing on the front lines?
I think the budget we've just had was pretty much steady as she goes. I tried to be a big advocate of the small business community, and I'm not sure they really understand what that is. And I wasn't sure before the budget started, and I'm still not sure. But that is the majority of what the UK economy is. Speaking to a lot of small business owners, they are worried about the future, but into high interest rates. But they're also a very resilient bunch. And I suspect in 18 months' time, they'll be a lot happier about where they are than they are at the moment. The uncertainty tends to kill them.
The uncertainty is the biggest killer, I think. But yeah, I don't want to keep you long, so let's get on with the show. So, as listeners may know, the Part 26A restructuring plan is a relatively new addition to the English insolvency regime and can provide a distressed company with a flexible option in dealing with its debts. I mean, the recent administration of Goodbox Co Labs Limited only further highlights this flexibility. So in most circumstances, you would think a restructuring plan would be proposed by the administrators when a company is in administration. But it's 2023 and the world is no longer a normal place. Proposing a restructuring plan by the administrators would have been seen as maybe too normal. But so in the case of Goodbox, it provided a groundbreaking precedent for creditor-led restructuring plans and the necessity of company consent. The groundbreaking precedent sent LinkedIn to overdrive, with every law firm providing its own analysis on the decision. Funnily enough, my own post about the decision led to this recording for members. So rather than me talk about the decision and how my original LinkedIn post contained an error, it is best to hear from Jeremy first. So, first question, can you provide members with some background to the appointment, please?
Certainly. So, for the first day, I did think about spending an hour listing out all the things I didn't like about our legal brethren's reporting, but I thought that was probably a little bit too emotional. But I was slightly concerned at how very adversarial most of it is written.
Right.
But no one seemed to ever to ask why, which is kind of the whole point of this, isn't it? Why would our administrator not be the author of a Part 26A scheme in these circumstances? Before we get into detail, this was an incredibly challenging appointment for us. And the team here, which is Patrick, Shireen, Patricia, George, and our lawyer Andrew Laycock and Greg and Annette from Neos IT, without them, we would have been absolutely scuppered. As it evolved and as issues arose, we were very lucky to have the people with us. Otherwise, we would have been in a very difficult place. The first thing probably to say is that thinking of this as a insolvency restructuring is probably not the right way to do it. This is predominantly a takeover by NGI. A clunky takeover, but that's what it is. And the concept of a Part 26A scheme was actually in NGI's mind when they first approached us in March. Now, for a number of reasons we won't go into, we were only really ready to act any particular way in the early part of June. And certainly there was a number of shenanigans with the application, and there was a potential pre-pack administration that was on the hoof. But in the end, the administration order that was made was very, very focused on a restructuring plan, either through a Part 26A or a CVA. Now, we were quite happy to sign off on that because there was funding for the administration, and there was funding, or we were told there was funding from the shareholder group to move it forward. Our initial plan, though, was unfortunately based almost 100% on information that NGI had.
Okay.
Because they were the applicant and we didn't really have access to the directors. So the position was it was going to be very light touch. We thought there'd be little FCA involvement and it would either be a restructuring plan through a Part 26A or other. Now, the FCA made their position very clear to us inside the 48 hours about how much involvement they were going to have. And certainly we were slightly surprised at just how chaotic Goodbox was in terms of its accounting functions and its IT infrastructure, none of which we were aware of before.
Yeah.
And all of which was very important to the FCA. They made it very clear to us if they didn't like the answer, they'd be pulling everything. So going from a situation where a fairly light touch commercial restructuring was going into a very heavy, highly regulated approach, which is completely different. Oh yes, also the other course to mention is that Goodbox didn't have an office. So the concept of sitting there and placing an assistant or a senior next to someone and say, right, don't move till they let you have the information was a little bit difficult. So everything was on Zoom or Teams. We're quite reliant on the good faith and goodwill of the staff, which predominantly we had, which is great. But it was very difficult, very, very difficult sometimes to get our point across in those circumstances. So anyway, the original plan was 3 months, Part 26A scheme, which we'd seen a first draft of sort of April, May time. And we said, there's an awful lot of work to do with this, but let's park it till we see what we've got. So the whole thing was going to last 3 months. So 7 months later, we're still going. There is no finalised Part 26A scheme. There are issues with what we've got, what we were being seen.
Yeah.
And certainly Patrick and I felt very uncomfortable being the authors of something which in effect was a clunky takeover of the business. And we didn't think that was the place of an administrator, and particularly when a number of the much larger creditors were particularly anti it. Now, clearly, the fundamentals were there, as the judge mentioned, in that those creditors, except some investment classes, are going to get all their money back. Fantastic. All the costs of the administration are going to get paid for. But there were a number of ancillary things in there that we just really struggled with. Not least, the plan was specific in terms of NGI, in essence, would be controlling things like administrator costs. And NGI were a minority shareholder and a very disputed creditor is probably the best way to do it. They will say that they were owed about £1 million. The directors would have a very, very different opinion.
Yeah.
So the plan, in essence, bakes in a claim of £900,000. So by us being the authors of that, we thought that was a clear and obvious conflict of interest. But there were others. And in essence, the NGI directors drafted the Part 26A scheme. And they encouraged us, Patrick and I, to put our names into it. Again, we pointed out the bits and pieces that we struggled with.
Yeah.
And we were told, that's a scheme, put your names in it. And we said, well, we can't really do that then, which was a position that was adopted by 4 or 5 other insolvency practitioners, most of whom rang me.
Yeah.
And we chatted about it. And my position was always that fundamentally we're not against it, because we never were against it. But the question is, are you prepared to sign up with these issues that there are associated with it? And of those other insolvency firms, none of them were until the presence of the scheme administrator that came onto the scene, which again was very late in the piece. So we then in a situation where there is a scheme, we know it works for the unsecured creditors, we know that we have to, or for most of the unsecured creditors, we know it's ticking the boxes in terms of the benefits of what a Part 26A scheme should do. And we also know that there are some very large creditors who are very anti, and that we have concerns about quite a lot of the detail. So we thought all we can really do is take a neutral stance. As far as I think the judge again says that if we actually say we're not prepared to accept it, then it dies. So we weren't prepared to do that. We weren't prepared to back it either because of the clear conflicts of interest that we saw in it. And what we did do is speak to all of the creditors to tell them what our position was. Now, the other big issue here is that this is a very small company. If we'd have put 2 or 3 noughts onto the end of everything, then this probably would have been a council-led argument over quite a long period of time, and all of the issues that various individuals had would have been aired in significant detail. But that wasn't there. It's not a big company. Most of the large creditors were of the view that they accepted they had already lost.
Yeah.
And whereas they did not like what was being proposed and were very willing and actually were suggesting that we should be trying to sell the business, the outcome for them they viewed as being a much better outcome if we did sell the business and then proceed to liquidation. that they weren't really prepared to fund legal representation to have their position put to the court. So we took a view that, okay, so we are neutral, we're not going to vote against, and we're not going to vote for, but if we collect all of the points that everyone has made, and we can add our bits that we're not sure, ignoring the Insolvency Act when it doesn't suit you really works either, that we can let the court have everything it needs to do to make its decision. And that is the approach we adopted. And we got some very good feedback from the vast majority of the creditors who were not enamoured with the process. But you ended up with two sets of creditors, those that had a vested interest in the thing going forward and those that probably didn't. So all the ones with a vested interest voted for it, and all the ones who didn't have a vested interest or had concerns that were more compliancy based voted against. So again, it's more than a commercial decision when the FCA is saying, if we don't like the compliance structure of this, we're going to pull the whole thing anyway. The analogy of a rock and a hard place is a good one. So we then get to the point where we have our meetings, and as with Frost Group as a creditor, we said, well, in essence, by voting for this, we talked about it. How do we get the court to understand that there are conflicts of interest? And the best way we came up to was being neutral as administrators, but Frost Group voting against the plan. Because the plan sought to significantly minimise the costs for NGI to take control of agreeing the cost of the administrator. That puts you in a difficult position anyway, so we thought that needs to be pointed out to the court. Also, while being neutral, there were two positions to adopt. So we got neutrality, we're in the court. I'm not saying we were surprised that the court voted the way it did. There were an awful lot of reasons why the court would not vote the way it did. Some of the issues we thought were fundamental, but because they had not been put by counsel on behalf of a creditor or a regulator, the court seems to have taken the view that they weren't that difficult. They weren't that bothered about it, which is probably right, as much to do with this wasn't a large case. And you sit there thinking, well, I wish it had been a much larger case, because I think we'd have got a much more usable piece of judgment, because there's always weakness in this. And I think that it would be useful, for the next administrator to be in a similar position to use Goodbox, because the ideas of Goodbox are right, and to possibly put together a fairly detailed, this is what you need to have in your plan, and show that to the court. Now, we did that not in one big document, but we did that over a period of time and got very little back, but I think it would look better for everybody. So we're in a situation where we're at the final hearing. So I've actually missed a reasonably key bit in that our relationship with NGI was never particularly great. Their view was, as they were paying, they should get to decide who does what and when they do it. It's not a position I think that any administrators listening to this would be happy to sign up to. So there was always going to be friction there. And when we stopped doing what they thought we should be doing, we all got very argumentative and the funding stopped. So we hadn't actually been funded, even though the witness evidence didn't necessarily say that. We had not been funded and were running out of money. And we had an administration appointment which basically didn't deal with the sale of assets. So we had to go to court to get a sale through.
Yeah.
And we couldn't, when we made our application for the sale, we had concerns whether the Part 26A would work, and thought, well, if this doesn't work, we're going to have to sell very quickly, and we didn't want to do an emergency application at the last minute on a small job, potentially over Christmas, which is where we were.
And that's very interesting, because you don't get that from reading judgment or lawyers' reviews of it, that NGI pulled funding and you was running out there, and that's the reason why you did that application in terms of sale of business.
NGI would say they weren't putting funding and they were always going to fund it. You can say that, but when there was no funding turning up into the bank account, you have to go with what's actually happening.
Yes, yeah.
Not what is said to be happening. So we're in that point. So we make our application, we need to sell. And the order's actually made, deals with the Insolvency Act bits and says, well, no, you've got to comply with the Insolvency Act, which is fantastic. And from a wholly selfish position, the order that's actually made is actually more beneficial than the application we made. So that's just a matter of commercial and reality for Frost Group Limited. And again, us saying that would have looked not very good on the old conflict of interest point. So in the end, we've never not wanted Goodbox to succeed. We think it's a really good idea, and bits of it work ferociously well. Other bits were seriously struggling, which is why we were involved in the first place. And I'm hopeful that we'll still see the brand knocking around in 10 or 15 years. There are things they had to resolve, which I think are dealt with in various witness evidence in the court application. I hope they solve them. If I thought it was bang on they would have solved it, it would have been easier to support it. It's interesting, it's detailed, it's complicated, And I say it was a very, very challenging piece of work for us that we're grateful we were involved in, and we're also quite grateful it stopped.
Well, it's a very unique case of obviously the first creditor-led proposed restructuring plan, and obviously it's come to the Frost Group. So, in one of the questions, you say you was appointed, and the restructuring plan was looking to be 3 months, but it turned out that you got to the 7-month mark. What was the delay? Was it putting the restructuring plan together was complex, or it was just maybe NGI slowing things down? What's your thoughts?
I think NGI, they dealt with one thing at a time.
Mm.
Part 26, we saw a page and a half of what they wanted in a Part 26A scheme about July, and we said, no, it's got to be a lot more detailed than that. And it just took a long time to get something that someone was prepared to put their name on. What tended to happen was that NGI directors would draft it and then hand it to various people for comment. And then either we gave some comments, and say a lot of the time that our comments weren't considered. And then it was going to various sets of solicitors as well. And they had the similar sort of, I suspect they had the similar sort of conversations that we had. So what was being put in wasn't something they felt comfortable dealing with.
Do you think, so when I say R3, there's Alison Goldthorpe. She's a R3 former council member, or she's on council at the moment, but she's been putting together a R3 restructuring plan example, detailing everything that needs to go into a restructuring plan for SMEs to make it easier. Do you think if we had that material available, that would have made it maybe easier for NGI to put one together at an earlier stage? Because there's nothing out there, is in terms of helping to put a restructuring plan together?
That's right. I mean, Patrick and I had several conversations about it, is that how long it would take us to put together, whether it was going to get funded, whether we could ever sign it off as being achievable. And as I said, we were pointing out, I mean, most insolvency practitioners of a given age tended to start with a blank sheet of paper and work out what they were doing from then. If you have something that within it tells you you need to cover these points, then at least if you choose not to cover them, then you've made a conscious decision. And I don't think necessarily the judge will, in this particular case, in the Goodbox case, the judge was liberal in terms of pragmatic about what was in the plan. So, I mean, I'd encourage Alison to put as much in as possible with a caveat on the bottom saying you should aim to have this. If it's a smaller company, you might not need bits of it for the judge still to agree with it. But, I think you're always going to have to be slightly more saying, I want to do a Part 26A scheme. Thank you. Clearly need more than that, but it doesn't need to be gold-plated and beautifully crafted document for the court to consider it and accept it.
In that respect, do you see them having a place in the SME market? Do you see them becoming more prevalent in the future?
I think Goodbox is as an outlier. I think the process is too clunky. Anything that requires 2 court hearings is, by definition, clunky. From when we started this, I thought that we could achieve everything that needed to be achieved using a CVA, except giving NGI control. That was the bit that there was a little bit of a falling out over. I would still go with, if the funding was available to me as administrator, I would have preferred a CVA. I think we could have done it quite cheaply, a lot more cheaply than it did cost, and we would have achieved a restructuring.
But it's all down to NGI and that control element, I suppose. Yeah. Okay.
So it didn't fulfil their need. That's why I say at the beginning, this was a funky takeover rather than a restructuring. Think of it as that.
Yeah.
And you are probably going to get to the right answers to why certain things happened, rather than think of it as just a white knight coming in from the cold. You're coming in to whip up the company onto its white charger and just disappear off to the distance.
I think you've covered most of my questions I had to ask, but is there anything else you wish to highlight to members in dealing with restructuring plans, or in particular credit-led ones, or anything else you want to highlight in terms of the decision in Goodbox?
Do you know what? I think I've probably said everything I should say, and probably some stuff I shouldn't say already. So it's probably best, I think, that we draw a line under it now. I mean, I think, well, the only thing to say is just reiterate the point. This was not a big case, and it would have been, if unlimited money would have been a very interesting position, because various creditors would have been suspected of being very forceful about what they wanted to happen. We didn't quite get that in front of the court, which is what it is, but still, I was always, when we signed up, Patrick and I signed up to this, we were very happy to be involved in a plan that restructured Goodbox. And now we're very proud that we were part of the restructuring of Goodbox, and that we managed to solve most of the problems that were presented to us. Just wish we'd have known about them beforehand, because it would have been a little bit easier to manage. But that it was ever thus. I mean, that's why we do insolvency, isn't it? We don't do insolvency to decide that Thursday of the month we're going to do the cash flow forecast.
No, you're right. And no, it is something that the Frost Group should be proud of. And you say it wasn't a big case, but took LinkedIn by storm.
Oh, yeah.
But no, Jeremy, thank you very much for joining me today and talking about Goodbox. It's been really interesting to hear from you directly, and something I'm sure a lot of our members will enjoy. So finally, and with all guests on the R3 podcast, I ask this question. What is the one thing you have learned during your career so far that has stayed with you throughout?
The impossible sometimes happens, and you've got to accept that it might.
Okay, that's good. I like that. No, I do like that.
If someone says that's never going to happen, that's never going to happen, and that doesn't mean it's not ever going to happen. It just means they don't think it's never going to happen, and you should probably still have an idea of your mind with what would happen if that happens.
No, Jeremy, it's been lovely to chat with you, and this has been a really interesting discussion, so thank you very much. Thank you for listening to this latest episode of the R3 podcast. I hope you found the discussion informative and useful. I think it is worth mentioning that the court only has power to sanction a scheme or plan where the jurisdictional requirements of Section 901A of the Companies Act are met. In this case, the court concluded that a restructuring plan and a scheme of arrangement requires the consent of a debtor and directed the administrators to give their consent to the plan. So this is what the judge said. There is, however, a dispute as to whether there is inherently a fourth condition which applies under Section 901A. That is broadly whether there is a fourth condition, which is that the company itself, by its directors or shareholders, or where the company is in an insolvent regime by the relevant office holder, example liquidator or administrator, must consent to and agree to enter into the relevant scheme or arrangement and or compromise. Key takeaway from the decision is that debtor consent is required for a restructuring plan / scheme of arrangement. Thank you again to Jeremy for joining me today and being so open and honest about the case and the decisions taken by him and his office. Should any members wish to be a guest on the R3 podcast, please contact me. My contact details are on the R3 website or simply message me on LinkedIn. Thank you very much. Stay safe.